at the Universidade Federal do Espírito Santo with fishing communities, and has also been working on the issues of sustainability and comparison of law, community, and environment in both the United States and in Brazil. So this is going to be extremely interesting. I think we'll learn a little bit about Dr. Filgueiras' stay at Stanford University when recently he studied there as a visiting fellow and worked with a community that was trying to enter into dialogue with plans to create a high-speed rail. So you can see that Dr. Filgueiras is very interested in community and environment and the tensions and challenges that befall those kinds of communications. So I am very pleased to present Dr. Filgueiras.
Thank you. I would like to thank Professor Janet and all the Department of Anthropology and Latin American Studies. This that I'm going to present here is part of my PhD research that I finished last year. My research was funded by CAPES, which is a Brazilian foundation, and also by Fulbright. So what I'm going to tell you here today is a little bit of general aspects of environmental litigation in Brazil and in the US. And after that, we're going to take a look at one specific case, one specific Brazilian case. So when I'll show you general aspects of environmental litigation in Brazil and in the US, I will try to show you who are the major players in environmental public interest litigation in both countries, who are the ones represented by these players, and the scope of the public interest that can be vindicated in court. Meaning like how public interest is understood in the legal field in both countries. My point is that these are not just formal differences, but that they express broader aspects of each society's legal and political cultures, as we will see. So in the case of Brazil, we can ask who litigates for public interest in Brazil? And in the Brazilian case, it was in 1985, a few years before the enacting of a new constitution. So we were ending our right-wing dictatorship and trying to build a democratic country. And when new legislation was enacted regarding environmental litigation in Brazil. So it created a new type of legal action that we call public civil action, that was created to protect a specific kind of rights that we call in Brazil diffuse rights. The environment, in a general sense, is a typical example of diffuse rights, meaning rights that belong not to individuals, but to imprecise groups like the future generations or all Brazilians, and also rights that relate to objects that cannot be divided in individual parts, for example, the beach or the ocean of Copacabana. So this same legislation that created Ação Civil Pública gave also new powers to Ministério Público. So Ministério Público is an institution that, besides prosecuting criminal offenses, was thereon allowed to start civil public actions to protect public interests. So who is Ministério Público? Who is this institution that has such an important role in environmental litigation in Brazil? Ministério Público is a branch of Brazilian government that is independent from the other three, from the executive, the legislative, and the judicial. And its members are admitted through public exams and receive very high wages for Brazilian standards. So it's like a bureaucratic elite. As an example, they start with $10,000 a month, while a PhD professor in a federal university starts at $3,000 a month. They also have privileges, such as only being fired fired after a judicial process. So to fire a member of Ministério Público, he has to go through a full trial, and you cannot fire him through administrative procedures. And besides that, they are not accountable for frivolous litigation. For example, in Brazil, if you start an action that is proved to be in bad faith, you have to pay a fine. In the case of members of Ministério Público, they don't have to do that. So they are very protected in that sense. There are some doutrinadores. Doutrinadores are law specialists who are either from the academy or from the judicial practice that write about law in Brazil. Some of them are very enthusiastic about the role of the Ministério Público in defending the public interest. So there's this example here, Edis Milaré. He's a prosecutor himself, and he's also a law scholar. So I reproduce here a little quote that shows how he sees the role of Ministério Público. So as you can see, he says, as private interests mingle with the public, there appears the protective figure of the Ministério Público for the confidence it inspires, the impartiality and integrity of its members in face of the role that the Constitution laws assure them. Fighting for an ideal that is not theirs but public, the members of the Ministério Público perform a work that is like an altruistic crusade, without being able to assign their members the financial rewards of lawyers. So you can see that it's a very idealistic view of the role of the Ministério Público. And you can find a lot of this in law books in Brazil, and also in the discourse of the members of the Ministério Público, when they talk about their own role, that in general is like, it's in these terms that they put the role of, their role, the things that they do. Nonetheless, there's an increasing skepticism about the Ministério Público by scholars from social sciences, by political elites that might have to face legal challenging. That's an important aspect. But also from groups like traditional fishermen, as we will see in the end of the presentation, that might be accused of degrading the environment. So the position of Ministério Público as a player in environmental litigation in Brazil, as someone who should defend public interest, is very ambiguous. Although it's formally a part in the judicial process, suing companies or the executive, for example, the members of the Ministério Público are considered by law and present themselves as being impartial, since they are legally charged of representing the public interest. So this other legal scholar, who is also a prosecutor himself, he says that Ministério Público is an impartial part, which is a very, very paradoxical, right? So you can find this in a lot of legal law books in Brazil. As an example of this paradox, in hearings, the prosecutors, they sit in the right side of the judge, in a higher position than the defendant lawyers. This shows how, although parts in the trial, they are seen as closer to the justice than the defendants. It is expressed in the judicial ritual itself, this ambiguity I'm talking about. The prosecutor sits on the right side of the judge in a higher position than the defendants. Well, a second issue with the Ministério Público is that the law allows them to start public interest actions, even if they have not received any formal complaint from any group of citizens. In these cases, Ministério Público usually presents its legal actions as in the name of the whole society and its future generations. That raises the question of whose public interests are they representing in fact. So whose public interests are the members of Ministério Público defending? One important fact that I didn't say, that I didn't mention, is that NGOs are also allowed to start public civil actions in Brazil. And besides that, there's also the popular action that allows citizens to start public actions, public interest litigation. So there's an interesting controversy in Brazil about the fact that although NGOs and citizens or allowed to start public interest litigation, most of the litigation is started by the Ministério Público. So there's a great discussion in Brazil about that. So instead of trying to answer that question myself, I will indicate here some of the underlying notions present in some of the answers given to it by doutrinadores, those law specialists, and people on the ground, people like members of social movements and stuff like that. So here are some quotes from Brazilian scholars about why people expect the Ministério Público to start actions. So this legal scholar, Ada Pellegrini, she said that it's because of the very individualistic and little associative mentality of our people. Another scholar said that, Mazzilli, that in Brazil we accept arbitrary actions by our representatives because of our culture underdevelopment. So these are Brazilian legal scholars talking about their own society, and explaining why citizens don't start actions this way, because we were supposed not to be enough associative, or because we have like some kind of culture underdevelopment. In Brazilian legal doctrine, these notions are condensed in the social category hipossuficientes, which has a wide range of meaning as like poor, weak, incapable, lacking culture, lacking technical knowledge, and so on. My point is that there's a complementary association between the enthusiastic view of the members of Ministério Público as altruistic crusaders, almost like superheroes, and the general view of citizens as being hipossuficientes or being weak. There's a complementary relation between these two ideas. On the other hand, I have quotes here from social movement and a member of the construction industry that specifically in the city I live has been challenged by the Ministério Público because they want to build buildings by the beach or areas that they were not supposed to do. So FDVV is a social movement that was fighting the construction industry. When I asked them why don't they start civil actions themselves, public interest actions themselves, they said, the Ministério Público is stronger than us, so it can better represent us in court. And they said also that they were afraid that if we start an action ourselves, we can suffer legal retaliation from the defendants. The member of the industry, the construction industry, he said to me that in his view, the relation of society to the Ministério Público is based on respect and fear. Most investigated people think, if I receive agreement from Ministério Público, I have no further problems. So anyone who is investigated by the Ministério Público will have his public image damaged. That's why people prefer to get in agreement fast. So there's a lot of news about what Ministério Público is doing. Sometimes people are still being investigated, but they will show up in the news as being investigated by the Ministério Público, and that damaged their public image. That's what he was saying. So, summarizing what we have in Brazil, our model of environmental litigation is based on is framed in a bureaucratic hierarchical model where Ministério Público, an elite of public servants, can act in the name of the whole society to protect its weak citizens and are not very accountable to society. They can make, for example, an environmental agency accountable, but themselves are not very accountable to society. So this is a general view of how environmental litigation works in Brazil and the role of the Ministério Público. Now I would like to move to talk a little bit about the American model, and for me it's very important to get feedback from you in this subject, because here I am, a Brazilian, talking about your society. So who litigates for public interest in the US? Well, in the US it was in the 70s that American government enacted environmental statutes allowing citizen actions. The environmental statutes, they have shifting fees provisions that allow private public interest firms, law firms, to represent citizens against companies or federal agents and to be awarded reasonable attorney fees. In general, in the US, what is called the American rule is each part will pay their own expenses with attorneys. But in the case of public interest litigation, when a group of citizens prevail in the merits, they can be awarded reasonable attorney fees by the court, right? So that's an incentive for people to litigate, for citizens to litigate and enforce law this way. Well, these private firms, they are somewhere in between pure entrepreneur firms and pure pro bono firms. They represent basically the tension between making a business of law and doing good. They don't take just any case just to make money, but on the other hand, making money is still a constraint for them to work in a case. Note that there's no such economic constraint for Ministério Público in Brazil, since they are public servants with high wages, right? So whose public interest these firms are representing? When you read like papers by legal scholars in the US, the underlying idea is that these private firms represent underrepresented groups like class, racial, or gender minorities who try to assess their rights through the courts. What I'm trying to emphasize here is that the term underrepresented does not necessarily carry the sense of weakness and of being incapable, which is present in the Brazilian category hipossuficiente. An example of how legal scholars in America see the role of citizens in public interest litigation. So this quote from this Matthew Burrows. He says, Congress sought citizens as useful for educating the court about complex regulatory issues. Indeed, citizens can bring to light certain factual information that other litigants might be unwilling or unable to raise. Citizens may also raise arguments that cause the court to examine or re-examine a legal issue. So this is a very different view of the role of the citizens when compared of the quotes I showed by Brazilian legal scholars. You know, here the idea is that it may be a little idealistic view of the model of American litigation. What we can see here is that citizens are seen as the ones who can like inform the court about complex regulatory issues, while in Brazil citizens are mostly seen as weak or incapable of representing their rights in court. So when I was talking about Brazil, I said that many times the Ministério Público acts in name of the whole Brazilian society and the next generations, right? In the case of the US, although most of the statutes from the 70s have the expression any citizen, referring to who can start a citizen action, and although President Nixon used the expression all Americans as the beneficiaries of this legislation, courts frequently apply legal tests that narrow the scope of the public interest that one can vindicate in court. So, in practice, what that means? That one cannot represent an undifferentiated public interest, like the interest of new generations or of American people. As an example, there's this case that is taught in environmental law classes in the United States about Sierra Club v. Morton. So in that case, in California, when Sierra Club tried to stop the building of a recreational park in a natural area, the court said it did not have a case or did not have a stand to sue because did not state in the complaint that members of Sierra Club were actual users of the area. In other words, one cannot sue in the name of an abstract or undifferentiated public interest. Like Sierra Club cannot just try to sue to protect the environment. It has to show that members of Sierra Club actually use that area and they have a stake in that case. That's different from Brazil, as I showed, where the Ministério Público usually presents its cases as representing the interests of all Brazilians, including the next generations. I have another file here that how can I, where I make this. So in this first part of the presentation, what I tried to do was tell who litigates in Brazil and the US. So in Brazil it's mostly Ministério Público, a bureaucratic elite, while in the US, private public interest law firms that depend on fee-shifting provisions of statutes. So who they represent? In Brazil, Ministério Público represent mostly hipossuficientes, the weak citizens that need protection, while in the US, the private law firms represent underrepresented or disadvantaged groups, minorities that want to protect their rights through the court. And how public interest is in general understood in each society. In Brazil, Ministério Público can act in the name of all Brazilian people and the next generations, especially in environmental cases, while in the US, private law firms need to represent groups that can be legally identifiable and that have a concrete stake at the case. As I'm trying to argue here, I don't think that these are just formal differences, but they tell us about aspects of each society's political and legal cultures. The fact that the environmental and public interest litigation constitutes a market in the US, and that in Brazil it's almost a monopoly of a bureaucratic elite, surely tells us about where each society believes the public interest will be better served, in the legal market or by a state bureaucracy. Why in the US groups can have difficulties bringing a case to court because their case doesn't interest any firm financially. In Brazil, groups can have difficulties if the Ministério Público does not take their case as a priority, and the criteria for that is always obscure. It's never very clear. So this is a general view of environmental litigation in both countries. And now I would like to present a specific case that I followed in Brazil. And we can see a little bit of what Ministério Público does in concrete cases. Well, it was in 2007 that the fishermen from Barra do Jucu, in Vila Velha, Barra do Jucu is a neighborhood in the southeast of Brazil. These fishermen had posted notice in their barracões de pesca, or like little houses where they kept their equipment by the beach, where the Ministério Público was noticing them that these houses would be removed because they were environmentally illegal. The fishermen had been notified of this possibility before, but through informal conversation with local NGOs and city personnel. These barracões, these little houses where they kept their equipment, were not only the places where they kept their equipment, but a symbol of the fishermen's presence at the beach, and were also objects that mediated specific social relationships. There were groups of fishermen that shared the barracões, right? They were not necessarily fishing partners, they were not necessarily fishing together, but their relationships were established by the fact they shared a barracão. So the barracão helped form clusters of social relationships. You have the partnerships that were like the productive unities that went to the ocean to fish, and you also have the group of barracão, that cluster of social relationships that were around one barracão. So the barracões were very important for the social structure of the group. This is a view of the beach. You can see the barracões in the bottom. This is a view of the barracões after the fishermen had already removed their equipment, after the Ministério Público told them to do it. This is a view inside of a barracão. The reason I don't have the whole person here is because he told me to focus on the equipment, not on him. So after the fishermen got this notice, they got the support of 2 state representatives that sent letters to the Ministério Público asking for time for the fishermen to prepare a project for the new barracões that would be built in accordance with environmental law. I myself also sent a document describing the fishermen's activities and affirming that they were traditional and therefore protected by law. Well, in Brazil there's no legal definition of what is a traditional people. A group can be officially labeled traditional when it vindicates the rights to a territory. For example, when fishermen demand the government to create a reserva extrativista marinha, that means an area protected for artisanal fisheries. Then a study will be made by government specialists to evaluate the demand. The most important criteria is not that the activities like fishing are only old in time, but ecologically sustainable, which will be established by the specialists, not by the fishermen. So one interesting fact is, for the fishermen to be considered traditional, they must show some kind of traditional knowledge of the environment. Nonetheless, who will establish if they are ecologically sustainable or not the fishermen with their own traditional knowledge, but the scientists and specialists of science of biology. So the traditional knowledge is a condition for them to be recognized traditional, but it's not through the traditional knowledge that they'll be evaluated as sustainable. An interesting point, I think. So in the case I am talking about, the prosecutor determined that although the barracões were traditional, she recognized that they were traditional, they were not in accordance with the environmental law. She also affirmed that the fishermen could build new ones, but that the older ones would have to be removed immediately. So she ordered the city to remove it, threatening to prosecute the mayor if they didn't do so. So it's very interesting that when you see the prosecutors talking about the job, they say that they prefer to settle out of court because they say that you can build more consensus. But actually, in concrete cases, what you see is them threatening to prosecute the parties in the conflict to make their will happen, at least in the most conflicts that I've been looking at. So this is a picture of the same area after the barracões were removed. So you can see that the city sent workers without any uniform. No. This all was presented in the local media, in the local news. So the fishermen interpreted that as the city trying not to relate itself to the removal of the barracões, since the workers will not be identified as city workers. This is a fisherman looking from the bottom of the hill to the beach, looking the work of the people that were removing the barracões. This is a fisherman serving water for the people who went there and removed the barracões. You met Marcelo. He went to the river.
Were the people who were shown in the first example on the beach the policemen, not the fishermen then? Those that were standing on the...
Here?
Yes.
Okay.
Those are the city workers?
City workers, and the ones sitting are fishermen. Watching. So the fishermen were convinced by a lawyer not to challenge the prosecutor in court, but to try to negotiate out of the court. Since the fishermen and I were inexperienced legal players, we accepted the suggestion. But today I think we should have tried to stop the prosecutor's action through the court. I interviewed the prosecutor responsible for this case and asked her about the fishermen's rights as a group that is recognized as being traditional, a category protected by the law. The prosecutor answered me on the record. She said, well, do you think they are really traditional? Well, you're an anthropologist, you should know better than me. I would have to study it a lot. We looked more through the environmental perspective. We thought that it would be easier for them to find another solution for their equipment. But of course, they use it for subsistence. So they are allowed to build new ones in accordance with the law. I believe that's an example of how the prosecutors can be arbitrary and not justify their choices in a reasonable way. Although considered less urgent than the environmental concerns, the rights of the fishermen were reaffirmed. They can rebuild the barracões, although the city didn't do it yet after 6 years. So what I'm trying to argue here is that their rights were recognized, I believe, not so much because their traditionality, but because of what was considered by the prosecutor to be poor economic conditions, which she called subsistence. What brings us back to the notion of being hyposufficient. So because they were weak, they were poor, they would be allowed to use the beach to continue fishing and having their house, but they have first to be in accordance with environmental law. So that's, and this is a representative of the city talking with the fishermen, explaining how the new project of the barracões would be. And this is 6 years ago. We had the city changed a lot, new people were elected, but the barracões were not rebuilt. So this is an example, a concrete case of a member of Ministério Público trying to protect the environment in Brazil. So that's basically what I wanted to present to you guys. So if you have any questions.
I was wondering how it was in contradiction to the environmental law and how it could have been built differently.
Okay, one of the things that was written in the document is, for example, that they didn't have like restrooms for them to use, you know. So, but that's because they live at Barra do Jucu, you know. So they only go there to work, so they can use their bathrooms at home, you know. They actually don't need restrooms in that place. The prosecutor also said that they had contaminated a source of water, which there was no source of water in that area. What happens is that when it rains, the water concentrates in one area, you know. So, and the fishermen never had access for the technical study, you know, on which the decision was based. So I think it was. She pointed a lot of superficial things about the environment. It was not like there was a specific kind of plant or animal that was being threatened or nothing like this. It was basically the idea of the beach that should be like a bucolic place, a place to be preserved as a wild place, you know, not to have this kind of buildings, especially because the prosecutor didn't say that, but most people that went to Barra do Jucu would say that looked like favelas, like slums, you know, it looked poor, it made the beach ugly, you know. So that was basically the idea that was underlying.
Are these member serious environmental transgressions such as the deforestation of the Amazon forest or something that might be more dangerous and substantial, or in that case, because the people opposing their actions are much more powerful and have many more political connections, they don't seem to make or do so much effort
they have a good reputation for fighting political elites, like very famous corrupt people, you know. So they do a lot of this too, you know. They say that before the 80s, when they got this new role, corrupt people, elites could do anything in Brazil and not be accountable. And now, after military people start this kind of actions, they can really fight these powerful people. And that happens a lot, you know. That happens a lot. They also do that. But the problem with the Ministério Público, I believe, is that they are not accountable to society. You know, there are not ways to society to control what they do. You can't sue a member of Ministério Público. You know, so sometimes they do a lot of like good stuff. If we are progressive people, for example, they may, because the prosecutors, they have a lot of independence between each other. You know, they don't act as a group. You know, each one, depending on their own personal views, they will emphasize one thing or the other, you know. So you can find very progressive prosecutors that fight for the rights of the Indians, for example, you know, or fight against people that cut wood in the Amazon, you know. But you can also find prosecutors that do this kind of thing, you know. So it's a paradox, the role of Ministério Público.
My understanding of the Delamorte case, involving a dam on the Xingu River that would affect the indigenous peoples as well as the rainforest environment, has created an opposition between the Ministério Público and the Supreme Court of Brazil. And it looks to me as though it's a stalemate. Am I understanding that correctly? What happens in such a case?
What is stalemate?
Like they are at the same level that they cannot make a decision.
Impasse.
Okay. Actually, that's one interesting thing. You know, the reason that in most conflicts, the prosecutors want to settle out of court is because once they go to court, the one who decides is the judge, or in the case of Suprema Court, the ministers of Suprema Court. So I believe that in that case, like the last word will be for the Supreme Court, right? Yeah, it was. Yeah, that's the reason they usually try to settle out of court, so they can make it the way they prefer, you know. Because if they go to court, so the judge will like impose his view or her view. I don't know if I answered it.
Well, I think it points to this critical area, which is what is the impact of the decision that is finally made, and who, you raised the question, who does the Ministerio stand for? In your case, for example, in the case of Marcio, I'm wondering if there's an interest group that hasn't been named that might be a tourism industry, perhaps? Who is behind the interest in removing the Bacoan from the beach?
In this case, it was an anonymous complaint. That can happen. You can make an anonymous complaint.
It's an anonymous complaint, but you know.
Yeah, in Barra do Jucu, there is one specific NGO that is very active in the area of environment, and it has had conflicts with the fishermen because they want to adjust the fishermen to the environment concerns. You know, they want the fishermen to clean the beach. They want the fishermen to be environmental guides to take tourists to show them. But the fishermen just want to fish, you know. But the environmental NGO thinks that they must be environmentally educated, you know, although they have a very sophisticated traditional knowledge of the environment. So I can't say like the members of this NGO made this anonymous complaint, you know, but there are groups in society that sees the barracões as like favelas, as slum, and wanted the beach to be like a wild place.
What about tourism?
What?
Tourism.
Tourism.
Tourism is not very strong in Barra do Jucu,
But
actually.
it can be.
Yeah, it can be, yeah.
that is of defending the notion that you may have some representative institution of the state arguing for the common good. You know, in a number of Latin American countries, there is a Ministerio Público, and they don't have to wait till you have to be a victim to do it. You know, it can take an initiative to do that. So I think it could be, of course, that in the case of Brazil, you have what you are calling the bureaucratic elite. But in terms of the theory of the common good and having institutions that represent it, it makes a great deal of sense to have such a body. You know, maybe it needs much greater perfection, but I would rather have a body that belongs to the public and is representative that can speak for events, as opposed to having someone that has to have experienced that problem in order for that ecological problem to be resolved. We have institutions today, and I am from Peru, and I don't know to what extent we have this Ministerio Público with the different subsidiaries, but I know that, for instance, there's now much more protection for consumers, and that is being done by an entity that doesn't have to wait till you complain to take the initiative. So how do you address that, the need for something much greater to speak for the common good?
Okay, yeah, I think I agree with you in many cases. As I said, in many cases the member of the Ministério Público helps a lot of groups, a lot of people. But I think that since the Ministério Público, there are not ways to make the members of the Ministério Público accountable to what they do, you know. We are dependent too much on the consciousness of the member of the Ministério Público, you know. Like they can really, for example, in this case, I think in specific cases, they may act in the name of in the name of the public interest, but actually they are just acting based on their own interest or personal views of the world. You know, it depends on the case, obviously. But I think in the case of Brazil, what we need is to make Ministério Público accountable. You know, give ways to society to control what Ministério Público does. You know, make the prosecutors have to explain better how they make their decisions, why did they start an action, like in the case of